Okay, so today we're going to start with very, very preliminary introduction to law. So I'm going to start with a basic question. Give me your definition of what the law is.
Rules to maintain order.
Rules for order. Anything else? Anybody else? When you hear the word law, what do you think of?
Restrictions.
Restrictions, okay.
A
Some
rule,
types of law are restrictions.
a rule set in place to avoid chaos.
Yeah, rules set in place to avoid chaos and rules and actions required by authority. Yeah. So the law is what's it? I think a couple of you also are saying it. It's to keep order. It's to prevent chaos. It's supposed to be there for everyone to follow. That way people know kind of what to do, or more importantly, what not to do. So the types of law that we're going to talk about, there's different types of law. There are some laws that dictate what should be done, and there's some types of law that forbid people from what they cannot do. You also have different types of laws in that some of them are criminal, so they're criminal, cases. Some of them are civil cases, and the purpose is always going to be the same. You want to look at the law, you want to see what it says, you want to know its origin, and that way you can kind of act accordingly. And just as an FYI, ignorance of the law is not an excuse. So if there's a law that says you cannot, let's say there's something that says you cannot sell weed to other people, but you were selling it. You can't then just say, well, I didn't know that was a law. Your ignorance of the law is not an excuse. It's not going to give you that out to say, well, I didn't know, that's why I did it. You'll still be held responsible. When we talk about also the law, there are, again, different classifications of it, and sometimes it's based on morality. So I want you to think about, is the law and morality, are they intertwined? Are they separated?
Can we just answer that freely?
Yeah, absolutely.
I think they're intertwined, but I think sometimes they get crossed up in like certain situations where things are done that are technically morally correct, but like could be defined as like illegal or wrong.
Can you give me an example of that?
Okay, this is a weird one, but there's just one that popped into my head. Say someone, I have a little sister, say someone beats up my little sister, and then I go and kill that person. Now, yes, that's morally correct. Like I would stand by that, but the law would prosecute me and I'd go to jail for the rest of my life.
So
Happily.
it's funny that you say that, because we are going to talk about criminal law and justified killings. So keep that scenario in mind. So for you, that's morally correct. You protected your sister. But is that, if you were to go to, you're going to get arrested, are you going to go to jail for that? That's going to be a question that we're going to answer when we talk about criminal law, which I think criminal law is actually on the syllabus for today. Okay, does anybody else want to say anything about morality and legality before I throw some examples at you? Anyone? Okay, so Amar, I'm going to ask you not to say anything in case that this scenario is familiar. So, but everybody else, feel free to answer. So if, again, and it's weird to do it on Zoom because I'm not there to dramatically act out what I would be doing in class, so just pretend. So if we were in a classroom and there was the 50 of us, or whatever the number was, 45, 40, and one of you was having an allergic reaction to peanuts, and I carry around an EpiPen. So you're having an allergic reaction, you can't breathe, your throat is clogging up, and I announce to the class, I have an EpiPen, and I run over to you, and I'm about to save your life by striking you with the EpiPen. And I stop, so I don't actually break skin. And then I say, you know what? Those EpiPens are really expensive now. I don't know if I want to use it on you guys because, like, what if my kid needs it? And then I kind of decide to back off and not use it. Do I have a moral obligation to help you? Yes or no? So we'll just do a show of hands. How many people say, yes, I have a moral obligation to help you? You can either raise your hands live or, okay. I'm just waiting for these things. 8 people, 9, okay. It's hard because now on Zoom, I gotta wait for this thing to tally itself up. All right, 11, 12, okay. How many people, put your hands down, let's clear the board. How many people say, as the professor, or no, as the professor, I am your professor, we're in class. How many people say, I do not have a moral obligation to help you? I do not have a moral obligation to help you. No, this is moral. I'm not asking about the law. I'm asking morally, do I have an obligation to help? So the question was, do I have a moral obligation to help you? Yes or no? And some people are saying yes, and some people are saying no. Now, it's easier if you actually just like talk, by the way, because this is annoying. How many people now by law do I have a legal obligation to help you?
No.
Do I have a
Nope.
legal
No.
obligation to help you?
No.
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 Yeah, I don't have a legal obligation. For the people that did say, yes, morally, I have an obligation to help. Morally, it's the right thing to do. I could be saving somebody's life. But legally, am I obligated to you? I asked you in the beginning of class, are you all above the age of 18? You said you were. If I had children, minors in my classroom, there'd be a different answer as far as legality is concerned, right? But you're all above the age of 18. Why aren't you carrying an EpiPen with you if you know you get an allergic reaction like that? That's on you. That's not on me. I don't have to save you. I don't have to waste my EpiPen on you, okay? Now, clear your minds. I'm going to change the fact pattern just a little bit. So again, you're having an allergic reaction. I take out my EpiPen. I come to you. I'm about to strike you to save your life. At that time, half of the class decides they can't take this much action. There's too much drama going on in this class. This is too much for business law. Somebody's having an allergic reaction and the professor's going to go stab them. What's going on here? Half the class leaves the classroom. After half the class leaves the classroom, I then say, oh no, I'm going to save my EpiPen. I don't want to do it. Now, don't forget, you said I don't have a legal obligation to help you in the first scenario. So the question now is, am I legally obligated to help you in the second scenario? And whatever, I don't want to see a show of hands now. I want you to give me an answer and I want you to back it up with a reason. Anyone?
No.
Daniel, I think Daniel, you said no, right? That was you?
Yeah,
So why do you say no, I do not have a legal obligation to help you?
because I don't think that the legality changes on the scenario if half the people leave and half the people stay.
Okay. Does anybody else have either the same or a different opinion?
Yeah, I'd probably back up what Daniel just said, unless there was a specific number of kids or students that had to be in the room, which I don't think would make any sense. But other than that, I don't
The
think
others left because you said you're gonna help. If they were willing to help, and you're not, they would jump in and help instead of you if you backed up. So now you have a legally.
Do you remember that from our last semester? That's why. So Amar is right. And the reason is there's people that left the room that were under the assumption that I was going to help. By them leaving, I have prevented them from now seeking help to this poor person. So the argument could be made, I prevented other people from helping. If they were all in the same room as I was, like the first scenario, there's no legal obligation on my part because everybody witnessed me saying I was going to help, me saying I wasn't going to help, so other people could jump in if they wanted to. But now that people left, half the class, they're under that assumption I was going to be of assistance. So sometimes changing the fact pattern just a little bit can change the outcome. Is it an absolute outcome? No. One of the things I want you to start thinking about in this class is how one piece of information can change the outcome of a scenario. It can be the difference between somebody going to jail, prison, or somebody not. Also, one of the things I want you to also kind of have an understanding of is locality changes things. Who's the judge on the bench? Who's the jury? Is this happening in New York City, or is this happening in some, town where there's more cows than people, right? Our background, our prejudices can also impact the outcome of a case, whether it's going to be prosecuted or it's not going to be prosecuted. So keep those things in mind. So this scenario that I just gave you was just a little test, a little tiny thing about morality, where it comes into play, the interplay between human interaction and whether or not something that we may have a sense that is moral may actually not be. So now the next thing I want to speak to you about is, oh, by the way, FYI, tip for this class. If I tell you to write something down, it's probably important. So I'm talking, great. It's wonderful. I want you to absorb it. I want you to have an understanding of it. But when I say, write this down, it means it's important. And I'm about to do that. So,
That's the secret.
huh?
That's the secret.
That's the secret. Yes. So now we're going to talk about, actually write this down. The judicial system is an adversarial system. The judicial system is an adversarial system. And I'm going to explain what that means. One more time, just write it out as I'm saying it. The judicial system is an adversarial system. And what that means is people have to initiate a proceeding in the court. I work in the court, right? I don't know what you people are doing outside in the real world. I only know if there's a problem by somebody initiating an action in the courthouse, somebody wanting to sue somebody else. And FYI, I work in civil, like a civil type court. I work in surrogates court, court of the dead. What happens to people's money when they pass away? What I do now is guardianship. So people who get money for infants or people who have disabilities and they need a guardian, that's what I do. So adversarial is the court system. It's got to be initiated, okay? Now, the next thing I'm going to talk about, that this is very important, okay? And it's the burden of proof. And I'm going to say this again so you pay attention. I always test on this. I always test on this, the burden of proof. Okay, so when we talk about the burden of proof, we talk about it in two different senses. One is in a civil sense, and one in a criminal sense. So let's start with criminal. When we talk about the burden of proof in a criminal case, it basically means what the district attorney's office needs to prove in order to put somebody away. The burden of proof in a criminal case is beyond all reasonable doubt. Okay, so the burden of proof, this is a write it down moment. The burden of proof in a criminal case is beyond all reasonable doubt. I'm going to explain what that means in a second. The burden of proof, this is also write it down. The burden of proof in a civil case is by preponderance of the evidence. Preponderance of the evidence. So, and I'm going to explain what each one means. So the
Can you please spell it?
I can actually, I'll put it in the chat. That's for civil. Okay. So for criminal, it's beyond all reasonable doubt. And for civil, it's by preponderance of the evidence. So now, what does that actually mean? So let's start with criminal. In a criminal case, can you give me, first of all, I'm going to go simple, basic. In a criminal case, give me an example of a criminal case.
I got one. I go kill my mother with a knife.
Okay, great. You killed your mom with a knife. Now, what is the outcome if you're found guilty? What's going to happen to you?
Gonna go to jail.
Prison, probably, right?
Prison.
And we're going to talk about the difference between jail and prison. You're going to talk about prison. So what actually happens to you? Your freedom is taken away. Okay? Let's say you rear-ended another car. What happens if you were found guilty and you actually did rear-end another car? What would happen to you?
You have
What
to
would be
pay
the outcome?
your
You have to
insurance.
pay,
Insurance.
right? It's monetary. So when we talk about the difference between criminal and civil, criminal, your freedom is being taken away. That is very valuable. And so in a criminal case, in order for a criminal case to be found, for somebody to be found guilty, the evidence that the district attorney's office must prove is beyond all reasonable doubt. And that's a high burden to prove. If we were to equate that on a number line between 1 and 100, what do you think the percentage would be that you would have to prove in a criminal case?
100%.
Nope, not
Was this
100.
90-10?
90-10? What does that mean?
95.
Like
95, yeah. It's definitely over the 90. It's definitely over the 90. There's no actual number percentage-wise, right? But when we're talking about a criminal case, we're saying that it's beyond all reasonable doubt. Reasonable doubt. What if the doubt wasn't reasonable? And that's why it's not 100%. So when we say proving a criminal case, all elements beyond all reasonable doubt, we break it down. So every criminal case has elements, and you're going to hear me talk about elements throughout the semester. Elements is the criteria in a case, in a whether it's criminal, whether it's civil, it's like it's the elements. It's the stuff that has to be there in order for you to prove a case. So in a criminal case, you need components that have to be there. So in the example that Mr. Gallo gave, he said he killed his mom. How did you kill her?
Stabbed her with a knife.
Stabbed her with a knife. Where did you stab her?
Right in the chest.
Okay, so he stabbed his mom in the chest. This is like playing Clue with a knife, right? Was it premeditated? Well, I don't even answer that because I don't want you to give too many details in case this ever happens. So is this something that, was it premeditated? Was he in danger? What were the circumstances surrounding it? The district attorney's office is going to have to prove that there was mens rea. We're going to talk about mens rea and actus rea in a few moments. He had the mental ability to do so, that he did in fact stab her, that she did in fact die. Because if you're bringing a murder charge, there has to be death. It's not just attempted murder. It's not like they survived, right? So there's so in a murder, and there's like different degrees of murder, there's different like criteria that have to be met. And the district attorney's office, in order for them to succeed in a case, they need to prove every single one of those elements. So it's hard for a district attorney or his or her office to prove cases beyond all reasonable doubt. That's why a lot of times in criminal cases, what happens? It's not actually going to trial. What happens?
Plea deal.
Plea deal. That's right. There's a lot of times plea deals, settlements that happen. Hey, listen, we're gonna, hey, Mr. Gallo, you know what? You did actually kill your mom, but there were some extenuating circumstances. Whether or not we're gonna actually bring it to a jury, I don't know. And rather than us waste the taxpayers' money in trying to prove you guilty and you spending 50 years in prison, how about you accept a 20-year deal now and you go to prison for 20 years? So then it's up to you. Do you want to take the gamble and go before a jury or not? It's up to you, right? So that's what a plea deal is. That's a criminal case. So it's above 90%. It's beyond all reasonable doubt. When we talk about a civil case, it's that car accident. And what you have to prove is not beyond all reasonable doubt. It's by preponderance of the evidence. So if you were to have a number line, what do you think the number would be if you're trying to prove preponderance of the evidence in a civil case? What do you think the number would be?
60%.
Nope.
51.
51. It's actually not even 51. It's any tiny bit over than 50. You just need to surpass 50. It's got to be more likely than not. So it's right, it's a little bit more than 50. You can say 51 if that makes you feel comfortable, if you don't, you know. But preponderance of the evidence in a civil case is more likely than not. So people can recover in a lot easier way in a civil case than to have a judgment in a criminal case. I'm going to bring an example to you. Now, a lot of you are probably too young and you did not actually live through this, but do you remember or know anything about the O.J. Simpson trial?
Yes.
Okay.
Yes.
What
Sure.
happened in the O.J. Simpson criminal trial?
The glove didn't fit.
Thank you very much. The glove did not fit. Yes. Was he found guilty or not guilty?
Not
Not
guilty.
guilty.
Not guilty. The level, the burden of proof was beyond all reasonable doubt. So there was reasonable doubt in the eyes of the jury. What happened in the civil case where the parents sued him?
He was guilty.
He was found guilty.
Right. Now, just so you know, we don't usually use, I want you to learn this. So I might use it just to kind of teach it to you. We don't use the words guilty in civil cases only because there's no level of guilt. He was found responsible. He had to pay. In a criminal case and in a civil case, the burden of proof is different. So you could be found, again, I'm using it incorrectly myself, you could be found guilty in a civil case, meaning the charges that were brought against you in a civil case where money is the recovery is lower. So it's a lower threshold. So you can succeed in a civil case and lose in a criminal case. And so why would you do one and not the other? A district attorney, this is now listening stuff, not writing. A district attorney's office brings a criminal case against somebody. It's the state, it's the city that's against the individual trying to put them in jail, because the outcome is they go to jail, they go to prison, they serve time, their freedom is taken away. In a civil case, somebody, another human being, another person, not a government agency, is bringing an action against another human being. And so if they succeed, there's going to be a monetary value. So it's a money as opposed to taking away somebody's freedom. Does anybody have any questions about the burden of proof between criminal and civil? No, good, okay.
Yes, sorry.
Yeah, go ahead.
Can you go to jail or prison for a civil case?
No,
Or does it have
no.
to be criminal?
Civil, the outcome is
Monetary?
monetary, unless there is an element of crime in it. So let's say you were driving drunk, you hit another car. So there's a car civil action, right? That you damaged another car, but as a result of your action, somebody lost their life because you were driving drunk. You can have two different cases. The civil would be the monetary damages of the cars. The criminal would be the loss of life, and that would be in criminal court. Got it? Sometimes if you don't pay your fines, there's a warrant for your arrest. And so if there's a warrant for your arrest because you didn't do what you're supposed to do, then you could be found, guilty and then go to jail that way, because now there's a warrant for your arrest as a result of your failures to pay certain fines. That also sometimes happens. Rarely, but it does happen. Okay? Any other questions before I move on?
Do you post slides of some sort?
No, I don't. I just talk. I just talk. But this video is recorded, and so I will put it on. What I do also as an FYI, since you brought it up, I upload it to YouTube, and then I'm going to send you the link. So you'll be able to watch it. Okay, so Also, this is all in your syllabus, in your reading material. So I know that for the first class, a lot of times people have not read in preparation for class, but the textbook that you've gotten, downloaded or whatever, it has all the stuff. It doesn't have my examples because that's just stuff that I do, but everything is in your textbook as far as the actual material itself. So moving on. When we talk about criminal case, it's also punishment, right? So when we talk about the criminal cases, it's punishment. And how do you punish people? There's actually a couple of different ways to punish people, right? You can actually imprison them, right? You can put them to death, which is not legal in all the states. But there's also fines that are associated with criminal activity. If a company commits a crime, you're not going to put the company itself in jail, in prison, right? You guys remember Enron? Does that sound familiar to you? Are you familiar with Enron? The largest Ponzi scheme in the entire world?
Yeah, but that happened, what, 40 years ago?
It wasn't that long ago, was it?
Not too certain on the date, but
All
I
right.
do remember that.
Okay. What about Bernie Madoff?
Oh, yes.
Okay.
That's
So that was more recent,
familiar.
right?
Yes.
I have lost track of all time. So Bernie Madoff, a huge Ponzi scheme, right? Bernie and the people that were collaborating with him ended up getting a prison sentence. But the company itself, they had to pay fines, they had to pay money back, because you cannot put a company in prison, but you can fine them so they can act as an example for other companies not to do wrongdoing. What else I would like to tell you about? Okay, this is also kind of fun. So remember I was talking about elements, and those are the things that kind of have to be proven. In a criminal act, there always has to be two separate components. This is a write it down moment. So in a crime, there's two essential elements, and that is the actus reus. I'm going to put this down in the chat because it is Latin. So you can actually go impress your friends, and if you want to talk Latin to them. Nobody wants to do that, right? Nobody? No? Okay, fine. Okay, it's the actus reus and the mens rea. So those are the two elements that are needed for every criminal act. Let's pretend for a moment you did not read in preparation for today. So you have no idea what the textbook says. But you have to now take a guess as to what do you think the actus reus element is? In plain English, what do you think that is?
Action?
Yes, it's action. In Joseph Gallo's example, it was the act of him stabbing his mom. That is the actual act. Now, what do you think the mens rea component means?
The mental fault or mental intent to do it.
Yeah, it's the mental component. So you need to have both in order for a criminal act to happen. You have to have thought about it, that premeditation, the act, the thinking to do it, and you also have the act itself. So if you have one without the other, you may not reach that level of criminal activity that you were originally thinking. So I'll give you an example. How many people here have an arch nemesis, if you will? Do you know what arch nemesis is? Somebody that you just, oh, can't stand this person. Anybody? Samantha, you have an arch nemesis?
Yeah.
Excellent. So don't tell us who it is, because if anything happens to them, I don't want to point to you. Have you ever thought about any criminal activity with respect to this particular person?
No, because I'm not like insane. I just don't
Okay,
want
well, all right. So I like that you preface it with I'm not insane. Sometimes, though, you just want to, this person. It could be a number of people. And, you know, my husband is here, so I can't talk about how many times I've wanted to kill him because I don't want him to hear it. But it's sometimes you just want to, a person. I could think about it. My son's coming out now to yell at me. I could think about it as much as I want. I know he heard it. He's in the room next door. Don't worry, I'm not going to really kill him. You could think about something as much as you want.
Exactly, yeah.
Right? But if you're not taking any steps to commit it, you have not committed a crime. Now, if you start Googling, right, how to blah, blah, blah to a person, right? Insert whatever mode of torture you want to put in there. And you start purchasing items to effectuate your thought process, then we have a problem.
Yeah.
Okay? Why? Because you could be charged with attempted murder, attempted assault, attempted whatever it is. The question is going to be, have you taken a substantial step to effectuate what was in your mind?
Wouldn't that,
At that point, yeah.
sorry, question.
That's
I
okay.
was just going to say, doesn't that have something to do with, like, wouldn't that be called conspiracy to commit murder? What's the difference between that
So
and...
conspiracy to commit is, it has to have another person.
Okay.
So conspiracy has to have a meeting between two people who are both. So if you hired somebody to kill somebody, that's a conspiracy between those two people.
Okay.
Otherwise, it could just be the attempt of X, Y, and Z. Okay, so that's the act. Again, what are the what are the elements of a criminal act? You need to know this. I always test on it. It's an easy one. Mens rea, actus rea. Okay, mental component and the actual action. Any questions before I move on to the next thing?
Yes, I do. I have a question.
Sure, go ahead.
How is it attempted even though, I mean, like, they just bought the items? There's no proof that they were actually going to do anything with the item.
So there's a question then of how far you've gone. So if you've Googled, right, how to do X, Y, and Z, that's on your history. If you've made threats to this person, just verbal, you haven't done anything, and somebody fears for their life, that could be an attempt. Your argument, your defense would be, well, I just wanted to look it up. I just wanted to buy the stuff just in case. Is that really going to hold water?
No.
Like, so there's the facts are going to now be very crucial in a case where it's attempted, because it's not like you shot at somebody and you missed, right? More facts are going to have to be taken into, but you can certainly be arrested. It doesn't mean you'll be found guilty. You could be. So don't Google anything and don't buy things if you're about to commit a crime. That's what I want you to get out of this. Okay?
Got it.
Okay. Especially this is all recorded, so I'm not telling anybody. Let me just say this nice and clear for everybody that's on this. I am not telling you to commit any crimes. I'm not telling you how to get away with any crimes. In class, there's certain scenarios that I give and present, but I'm not being recorded at that time. This, you got to kind of make it a little more vanilla when you're on Zoom, because you don't know who's going to find things. Okay. So this is a listening, not a writing down. When we talk about mens rea, there's actually 3 different types of mens rea. There's the purposeful kind, a knowing, and a reckless. And that also goes with how much intent or awareness you have of the crime and the harm you're about to commit. Again, that was a listening, just for giggles, about different types of mens rea, subset of the mens rea component for a criminal activity. The next thing I would like to speak to you about is just the difference of fault and its classification between a felony and a misdemeanor. And this is something also I want you to write down, because this is something I usually test on. When we talk about a felony and a misdemeanor, does anybody know what the difference is? Very simply put, what's the difference between a felony and a misdemeanor? Lucas.
Felony is a lot bigger of a crime than a misdemeanor.
Yeah.
Getting
Go
a
ahead.
ticket compared to like killing somebody.
Yeah, that certainly is. Yeah. Go ahead, Joseph.
I was going to say physical harm.
It could be physical harm, but it's also the outcome, the result. It's usually in a felony, you're going to be put in prison for a year. Your punishment is going to be more than a year. So with a felony, the punishment is going to be more than a year. And if you're imprisoned for more than a year, that's prison. If it's less than a year, that's jail, and that's misdemeanor. So this is a write it down moment. Felony, more than 1 year, prison. Misdemeanor, less than a year, jail. Okay.
Sorry. Can you get fined instead of a year of jail with a misdemeanor?
There's certainly sometimes fines associated with it, and it depends on the plea deal. There's actually statutorily in the criminal law, there are certain crimes that have a penalty along with jail time. It could be but that would be part of the plea deal. Misdemeanors are like, I don't know, obviously it's like wrong stuff to do, but they're not as bad obviously as killing or assault or stabbing somebody, or even it could be like conspiracy to commit fraud or actual fraud, grand larceny versus petty larceny. So there's different degrees of it. And in New York, it's very different, and it could be very different than Minnesota or Louisiana or California, because different states will have their states run and operating differently. So that's also something to keep in mind. So a lot of the things I'm telling you, they're either general or for New York, because I have no idea what the laws are in other states. Somebody asked the 3 types of mens rea. The 3 types of mens rea, and again, this was a listening one, not a writing one, but it's purposeful, it's knowing, and it's reckless. Okay, the next thing I want you to know, this is write it down, is what is vicarious liability? And vicarious liability is actually a topic that we're gonna hear about in different forms throughout the entire semester. Does anybody know what vicarious liability is? I'm gonna guess no. Vicarious liability is a really fun theory. I like it because I'm crazy like that. But vicarious liability is holding one person responsible for the actions of another. The law, FYI, is all about legal theories and principles and laws, right? Specific statutory things. So a lot of the times in this class, I'm going to talk to you about legal theories. And if you have a good attorney is an attorney that knows all these legal theories that can either get you off the hook or get you the maximum recovery because they know all these legal theories. So if you're going to pay a lot of money to an attorney when you hire them. You want to hire somebody that knows what they're doing so you can actually like get your what you want. Daniel, you have your hand up.
Yeah, is getting pulled over while your friend is drunk driving a vicarious liability?
Is it like, so your drunk friend is driving,
right,
and you are in the passenger seat?
Right.
Yeah, it could be. Why didn't you stop them? It could be. You could certainly be arrested for allowing somebody intoxicated. You're putting other people's lives. Your theory would be, I didn't know he was intoxicated, right? Your defense, because for every wrongdoing or everything that you could be arrested for or imprisoned for or whatnot, you also have to look at the defense. That's what I always look at. What is your argument as to why you should not be punished? I didn't know it was there. I had nothing to do with it. It wasn't mine. They were just giving me a ride from down the block. I couldn't stop them. I didn't know they were drinking. They acted the same. I didn't smell the alcohol in their breath. There's a million things that you could say, right? But it could also be. Usually vicarious liability is when a person has some kind of authority. And the best example I can actually give you in a criminal sense is for those of you who are familiar with I think it's football. Penn State, there was something that happened a couple of years ago. It might be more than a couple. Again, I have no concept of time anymore. Sandusky, does that sound familiar?
Yeah, Jerry Sandusky.
All right. Do you remember what happened?
Yeah, he molested an absurd amount of kids coming
Right.
through the prison.
And what happened to the head coach?
I do not remember, but I'm assuming he got in trouble.
Yes, he did. Why? The head coach knew about it and failed to stop it, failed to report it. So he was also fired. He also got punished for the acts of somebody else.
I also had a question. Like, wouldn't this like vicarious liability, the first thing that popped into my head when you explained it, like what Charles Manson did, because technically he didn't kill anyone, but he had followers that killed people, so like he was held responsible for those killings.
That certainly would be a charge that could be brought up against him. But his argument, his defense is, I didn't know what they were doing. I didn't get in their heads. I didn't, they're free people. They're on the outside. I'm on the inside. How could I? Was he aware? Did he fail to stop it? But he was already in prison. But yeah, the idea is, and if you actually bring it to everyday, forget even, I know we're talking about killing and all that good stuff and all, criminal stuff. Bring it to even something where you guys could be on the hook. If you are employed, if you have a job, and whether you're a manager or a subordinate, and somebody's either stealing time, not doing their time cards, doing something not correct in their place of employment, if you knew about it and you didn't report it, you could also be held responsible. I work in the courts. If I know that somebody's doing something wrong and I don't report it, I can get in trouble for it. That's vicarious liability. So the theory comes up in contracts. It comes up when we talk about agency later on. So the theory of vicarious liability, keep that in mind. Not only do you need to know it for your exam, but it's also a reoccurring theme for the semester. How are you guys doing so far? It's almost 8 o'clock, so you're doing good? Alive and well? All right, great.
Yep.
Excellent.
Yes.
So luckily for you, we're only doing criminal law today. We're not going to get into all the other stuff. Okay, this is I kind of mentioned this before. I'm going to say it again. How do you punish a corporation? You can imprison them, the people that are actually in charge of the company who knew what was going on, and you can also fine them. And how do you dictate how much money to fine them? It depends on the criminal activity that actually took place and what kind of example that you want to put out for other people. There are different types of crimes. And when we talk about elements, I'm going to give you this as an example. I'm going to put this in your chat. That way you also have an idea of crime. Okay. And when we talk about elements. So every element, a criminal, right? We talked about mens rea and the actus rea, but like, how do you define, that's a good way to put it, the definition. How do you define murder, robbery, larceny? So if you look at the definition of larceny, which is the example I just put in your chat, the actual definition of larceny is the trespassory taking, carrying away of, or exercising dominion or control over personal property of another with the intent of depriving the victim permanently of the goods. That's the actual definition of larceny. Now, you see how I have those numbers next to words? Number 1 is trespassory, number 2 is taking, number 3 carrying away. You see that? Those are the elements of the actual crime. You have to prove every element in order to have larceny. If you don't have one of them, you don't have larceny. And you have to prove each one by what? Beyond all reasonable doubt, because it's a criminal case. So if, in fact, let's say we were in class and I actually took away, somebody was sitting in the front, or somebody kind of came into the classroom, stole my bag and ran out. If they give it back to me 5 minutes later, the intent to deprive me of that item forever was not there, so they cannot be charged with larceny. Every element must be there and must be proven beyond all reasonable doubt in order for the charge to stick. Make sense? Okay, good. I'm gonna just move along. Okay, so, the textbook gives you a bunch of definitions then for embezzlement, robbery, burglary, all that stuff. Back in the day, I used to ask that, you take 2 of them and you memorize it. I don't really do that anymore because, if you want to look up robbery, if you want to look up burglary, you can kind of just look up what the definitions are, but just know be familiar with the concept of elements the definition of certain crimes. The next thing that we're going to actually now talk about is defenses, right? So when we talked about Mr. Gallo and his situation, do you want me to keep talking about it, or you want me to come up with a different one? I don't know your comfort level, huh?
No, you're good.
Okay.
I don't care. You're good.
But I don't want you to go and do this. I just want to be clear. Don't do it. Don't hurt your mom. So if it did actually happen, what would Mr. Gallo's defenses be?
I would probably claim insanity.
Okay, good. You would claim insanity, that you were not in your right mind. Good. That's a defense. What else? What else? Huh?
Self-defense.
Yes, sir. Gimme.
I said self-defense.
Self-defense. Okay, good. That's also a good one.
Active emotion.
Active emotion. So like a heat of the passion kind of thing?
Yeah.
Usually that's done when it's two people in a like a physical, like a husband and wife type of relationship. But the emotional aspect could be if he was a victim of abuse on a regular basis, right? And he felt like he had to do this in order to kind of protect his own life. Anything else that you could think of? If you were Mr. Gallo's attorney, what else could you come up with? Because you want to come up with as many defenses as possible, right? You want to get this guy off the hook so he's your client, so he doesn't go to prison. So we talked about self-defense. We talked about abuse. What else?
Maybe saving someone's life.
So he killed her in order to save somebody else's, perhaps his sister, right? Because we're going to have the whole family in there. Yeah, he was trying to save somebody else's life. Anything else?
You can try to blame someone else. And
Yes, exactly. I was waiting for somebody to say that. Duress. He was put under duress. Somebody made him do it. If he did not take that particular act, somebody else's life was going to be in danger. So somebody else made him do it. So those are all the defenses. Now, which defenses actually hold water? I'm going to change the fact pattern that we have just a little bit. Tell me if all the defenses that we had, would they still work or would they not work? In Mr. Gallo's example, he stabbed in the front, in the chest, right? Let's change it. Let's say he stabbed her in the back.
So no self-defense anymore.
Correct? No more self-defense. Because what does stabbing somebody in the back indicate?
They
snuck up on them.
No, well, he snuck up, either Mr. Gallo snuck up on his mom, or the assailant was fleeing, going away. So you can no longer use self-defense. Your life is no longer in danger. You see how just one fact can change and changes the outcome of the case? So those are some of the defenses. So we talked about that. Now, this is something important. This is a write it down. Actually, I'm going to give you the question first, and then we're going to talk about the write it down. Let's say somebody stole my favorite purse, my Louis Vuitton, blah, blah, blah. It's blue, it's Louis, I love it. It costs thousands of dollars. And let's say I was carrying a gun and I see this person, he stole my bag, ran away, and I can get a clear shot and I could shoot him. Can I do that? I can't do it. Am I going to be held liable is the question. I can shoot him, right? Am I going to be held liable for that action?
Yes.
Yep.
Why? Why yes? Why?
Your life's not in danger.
My life is not in danger. Give me a little bit more. What is the difference between the purse? I love that bag. Love it, love it, love it. Why can't I use force to get my property back?
Because he didn't touch you.
Didn't touch me. Let's say he touched my arm.
He bumped you and he ran away. It's not enough for
My life was not in danger. You cannot use, this is a write it down. This is the write it down moment. You cannot use physical force to protect property. You cannot use physical force to protect property. Mr. Gallo can use physical force to protect another human being, another life.
I have a question.
Yes, sir.
Yeah, I have a question after him.
So if somebody attacks you and tries to rob you and take your phone, take your money, you can't react by tackling them to the ground, punching them to protect your property?
You can't kill them. You can't take away their life. If they're just the example I gave was like a bag and they ran away. If somebody's assaulting you and now you feel like your life is in danger, you can take self-defense actions.
So wait,
And I'm going to leave it at that because, again, you know, when we're being recorded and I have to kind of be very careful with the things that come out of my mouth because I don't want it to be construed as any type of advice whatsoever. So I'm going to keep it as clear-cut as possible. You cannot use physical force to defend property. Physical force can be used to protect life. People do whatever they want, right? It's going to come down to whether you committed a crime. There was an example, I'm going to tell you, I don't remember the state that this took place in, but there was a guy who wanted to protect his house. He didn't want to be robbed. So he had a gun. I think it was in Texas or something. He had this shotgun. Who said it? Gallo.
Yeah,
of course you would know, right?
He sat in his garage, right? Or something like that.
Yeah, he had it actually like in a window. So when somebody would creep into his house, they would get shot. So somebody crept into his house to try to shoot, you know, rob him. They got shot and they sued. They sued the homeowner. And what happened, Mr. Gallo?
Not the farm. The farm.
They won.
They won and got
They
everything
won.
he owned.
Why? Because you can't use physical force to protect your property. The guy was like, I was going to go rob. I didn't know my life was going to be in danger. Now, do I personally agree with that outcome? It doesn't really matter because I didn't make that decision, right? So the bottom line is, can't use force to protect property.
Is there a difference between just physical force and deadly force in this scenario?
There is, yeah, I mean, listen, you know, me trying to hit somebody to get my stuff back could be possibly assault, because assault, the definition, it could be unwanted touching, right? But if I take a knife and I stab them in the leg, that can, you know, kill them if they bleed to death, right? So it really depends on the situation. And I want you to think about this and think long and hard. Because again, this is kind of, you know, students, right? Do you want to be in a situation where you have to defend your actions and possibly lose your life in prison because you made a stupid decision, right? If somebody's going to steal your stuff, let them. Your life is more valuable than stuff. File the report. Yeah, you're going to lose all your credit cards. Maybe you're going to lose the cash. Maybe you lose your bag. Maybe you lose your wallet. But what's more important? You got to kind of like, you know, what's more important, your life or your stuff? You know, and I tell you this, maybe when I was younger, I would have had a different answer, but I think things differently. I have kids now, you know, what's more important? So just kind of keep those things in mind. You want to defend your stuff, but don't die either. Okay, the next things, this is the last section for the evening. It's the Fourth and Fifth and Sixth Amendment. Okay, and once we go through that, then we'll be done for the night. So Fourth Amendment, Fifth Amendment, and Sixth Amendment are very important with respect to criminal activity. The Fourth Amendment, I'm going to actually put this all in your chat. That way you have it. It's just like my little notes. Okay. So Fourth Amendment. You've probably heard this before. It protects individuals against unreasonable searches and seizures, right? This I could have a lot of fun with because I always bring up the fact, especially with young people. Actually, now that COVID kind of, has changed the world, I don't know if it's as relevant anymore, but let's say you have a roommate and the police come knocking on your door And in the living situation that you have one bedroom, your roommate has another bedroom, and you have everything else is common. Bathroom, living room, it's all common area, kitchen. And the police knock and they say, hi, we're canvassing the area. There was a report of some items stolen in your building. Is it okay if we come in? And you say, sure, come on in. They come in, they're looking, or do you mind if we have a look around? They're all nice and friendly, right? Yeah, sure, come on in. They open the door, they don't see anything. They go into your roommate who's not home. They go into her room and they find the contraband, but they also find some drugs, they find a weapon. They seize it. Is that an illegal search?
Nope. You let them in.
It is illegal because the person was not there and they don't have warrants, maybe?
Yeah,
It
but you let them in.
depends. It depends. This is going to be a scenario where you're going to hear this a lot this semester. It's not a yes or a no. It depends. You would want to get more information. Historically speaking, do you go into your roommate's room and does he or she go into your room? Do you have free range? Was the door locked? Was it closed? Was it slightly ajar? Was the stuff in plain view or was it in a drawer? You're going to have, those are the questions that would be asked by both sides to kind of determine whether or not that was an illegal search. If I change the fact pattern just a little bit and say that the door was in fact locked and there was a sign on the person's door that says do not enter with a skull and crossbones, and then they went in, you would have a better chance of arguing they did not have the authority to enter that room even though the roommate was not in there, because the intent was never to have anybody else go in there. With the law, facts are so important. A good lawyer asks 1,001 questions to know every tiny detail, because one tiny detail can change the outcome. Okay? So that's your Fourth Amendment. Fruit of the poisonous tree. Also, if you did not have a warrant and you did seize property, are you able to use it or no? You have to then throw it out and you have to show that you would have, the only way to actually use then that evidence is to show that you would have been able to attain it through some other legal means. Okay? If you ever watch Law and Order, anyone? Law and Order, anyone? Okay, no. Law and Order, I'm a big time Law and Order SVU person, and I will tell you that you will now watch Law and Order differently after just today's lecture, because you're going to look at these things. The next thing that I want you to know is, to get a warrant, there has to be probable cause, right? So warrants are not just given, willy-nilly. There has to be probable cause as to what you're going to find and where you're going to find it, and then the judge kind of signs off on that. When I interned in the district attorney's office, I drafted warrants, and so we'd have to have that basis there in order for us to execute it, have the judge sign it, so that it could be used. Jeopardy. Okay. Fifth Amendment. Fifth Amendment. How many people have heard the phrase, I plead the fifth? I plead the fifth, right? Somebody asked how would they know if they have a warrant? They have to announce it. So if the officers have a warrant, they have to say, I have a warrant for your arrest. I have a warrant to search the premises. Do no-knock warrants need a probable cause, or is that a whole different subject? That is a whole different subject, because you would have to show urgency in why you're not knocking and announcing yourself in order to enter. So it could be fear of life or feel that the material is going to be destroyed if you announce yourself. So that's a class, that we can spend an entire day on criminal law. But this is the only stuff. This is the only night you're going to learn about criminal law. So I'm kind of just trying to put it in. Fifth. So like I was saying, the Fifth Amendment. I plead the fifth, meaning you have a right not to self-incriminate yourself. So if you are ever the subject of a criminal case, you do not have to take the stand. You do not have to testify. But let's keep it now, let's ask the questions. If you are a juror and the person who is being accused of murder or assault says they want to plead the fifth, they do not want to testify, what are you going to think? What are you going to think?
I think they're guilty.
You're going to think they're guilty. So that's not what the law says. The law says they are presumed innocent. The law says we are all innocent until proven guilty by what? Beyond all reasonable doubt. So is that fair that if you choose to exercise this amendment, this Fifth Amendment right not to actually testify, is it fair that the people, the members of your peers, that they're going to actually think that you are in fact guilty? That's what happens in life, right? So it's not just the law, you also have what I said in the beginning, life also kind of comes into play. So that is your Fifth Amendment. Your Sixth Amendment is the federal government gives you a speedy public trial, but the more important thing is that you have assistance of counsel. So the Sixth Amendment, federal government can give you a speedy, fast trial. They have to inform you of the accusations and the witnesses, but the more important thing is assistance of counsel. You get the assistance of counsel. Do you get the assistance of counsel in every single case that you want to take to court? Hey, I was rear-ended. Can I get an attorney to represent me? No, it's only for criminal cases where what? Your life, your freedom is in jeopardy. So if they're in jeopardy, you can get counsel, and that would be ask for counsel, and they free of charge. Does anybody, two questions. Number one, anybody have any questions on the material that we just covered? Okay. Number two, let me say this clearly in case you kind of came in late. You must follow the syllabus. One of my biggest pet peeves is like a third, a half, or the end of the semester, somebody asks me for the syllabus. Do not, because then I'm like, okay, so you have not listened, you have not paid attention, you have not read, and I have even less sympathy for you at that point. So make a friend. Here's all your Zoom people right now. Make a friend, and then have, if you miss material, you can, get it from your friend or get the syllabus. I'm going to post everything on Blackboard. If you have any questions, email me. That's fine, but please put in the subject line which section you're in. Are you my Monday or are you my Wednesday? That way I can at least follow that syllabus, because it is a little bit different. The people that have virtually raised their hands, I guess that's Mr. Gallo and Mr. Dioria. Mr. Gallo, let's start with you.
My fault. I just realized I had it up. Sorry.
All right. Mr. Doria?
Yes, I have a question regarding attendance.
Sure.
So if you can't make the actual live session, but you do watch the recording and you get the catchphrase or whatever it is and you write it down.
That's fine.
That's fine?
Yep.
Okay. All right. I just wanted to make sure. Thank you.
No problem.
Sorry. And regarding that same subject, we have to email them to you as soon as we have 10 phrases?
Yes. So it's usually going to be, towards the end of the semester, but before, maybe like 2 weeks before the final exam, you'll probably have 10 by that point. So as soon as you have 10, that guarantees you 100. You can just email me the whole thing. Any other questions? Did anybody come in late? Because I did take attendance already for today. So today there was no secret phrase. Did anybody come in late?
Wait, so if you have like the first 10 meetings, you came to the first 10 meetings, you have 10 phrases, you just send it and you're good?
Yep.
Okay.
You'll get 100%. You might want to still continue to follow, that way you do well on the exam, but you'll have 100 for that attendance portion.
Make sure. Okay.
Somebody asked a question. Oh wait, hold on. Oh. The assigned reading includes, it's the selected sections. So that's why I go into detail on the syllabus as far as, like what particular sections, because some things I don't really care about, or they're not that important, or they're not that relevant. If I put a case in the syllabus, read it, because I often ask during class, who wants to tell me about this case? So you also want to participate, because it shows that you're actually paying attention. And I don't think it's to know each other number. Okay. So there's some people here making friends. That's good. Good, make friends and
so for the chapter of a criminal law, only the subjects you mentioned, this is what we have to study, because I have the book, so I'm checking. There's other stuff we didn't go through. So
that's right. So you don't need it. It's whatever. I would say 95%, maybe 100, but I'm not going to go through the 100. 95% of the material that's on your exam is straight from these lectures. So if it's not something I cover on a lecture, I'm not going to test you on it, because I want to make sure you're hearing it from me and I'm explaining it the way I want you to know it. So if I'm not covering it in the lecture, chances are it's not going to be on your exam.
You mentioned that we have to know some elements for some crimes.
No, that was like, it's just for fun, but to know what the element, what the definition, what's an element of, you know, if I ask you what the elements are of a criminal, you know, act, you should know that it's actus and mens. And what does it mean? You know, I'll probably ask you what that means. I'm not going to ask, I don't think you know, I have to look at my exam, and I usually change it every semester to kind of like, you know, meet some specifics of, I don't think I'll ask about, but maybe like the week before the exam, you can ask me. I'll probably be done by then. Anybody have any other questions?
Yeah.
Okay.
Could you write your email in the chat?
Sure.
Thank you.
I honestly don't have my CSI one memorized because it's like it goes directly to my phone. If you need me for an emergency, this is the one you should use because that's my work one, and that's the one I check like 1,000 times a day. So, or you can Google me or whatever through the CSI chat thing, and then you can email me that way because I'll get those as well. But the Bekhit at NY Courts, I mean, I check that all the time. Also, if you email me between the hours of 9, like during work hours, I'm really good with email, but I might not like be getting to you during daytime hours because I work. Anybody else have any questions about your class business law venture that you're about to embark on?
Nope.
Nope. All right. All right. Well, if that's the case, if there's no other questions, have a great evening, and I will see you next week. Oh, check always the syllabus because, like, you know, days change when the exams are, topics, because I think like the first exam is not that far away from now. So just always check the syllabus. Okay. Okay. The end. Good night, everyone.
Have a good night, Professor.
Thanks. Have a nice night.